Well, you go to the Ninth Circuit, and it's a disgrace, and I'm going to put in a major complaint because you cannot win, if you're us, a case in the Ninth Circuit. And I think it's a disgrace.
Let me tell you exactly what just happened, because the way this story is being covered is bearing the part that actually matters. The Supreme Court of the United States, the same court Trump spent years trying to reshape, the same court whose decisions his team celebrated as historic victories, the same court that gave him the immunity framework his legal team had been fighting for since his first term, issued a direct, specific, enforceable order on immigration enforcement. Reinstate legal protections for asylum seekers. Stop deportations without proper hearings. Make real efforts to bring back individuals who were removed without the process they were legally owed. Not a suggestion, not a recommendation. A court order from the highest court in the land. And Donald Trump looked at it and said no.
The Supreme Court has delivered a monumental victory for the Constitution, the separation of powers, and the rule of law in striking down the excessive use of nationwide injunctions to interfere with the normal functioning of the executive branch. The Supreme Court has stopped the presidency itself. That's what they've done. And really, it's been an amazing period of time this last hour. There are people elated all over the country. I've seen such happiness and spirit. Sometimes you don't see that, but this case is very important. I was elected on a historic mandate, but in recent months we've seen a handful of radical left judges effectively try to overrule the rightful powers of the president to stop the American people from getting the policies that they voted for in record numbers.
The Supreme Court's emergency docket, also called the shadow docket or the interim docket, is for, well, emergencies. This is every time the federal government had a case there, back to the first Trump administration. And here's just 8 months into his second term. It's being used in record numbers.
Emergency applications used to be a very, very small and not especially divisive part of the Supreme Court's work. Now, this is the front lines.
Not only are there more of these cases, but President Trump is winning more than his predecessors have. And we don't really know why.
We don't know why, because with this shadowy process, the Supreme Court doesn't.
That single decision, the decision to openly defy a direct Supreme Court order, is the constitutional event that H.Res 353 was filed in response to. And if you want to understand why that resolution matters, why this moment is different from every other legal confrontation this administration has had with the courts, you need to understand the specific constitutional line that was crossed and what the founders built to address exactly this situation. Start with the court order itself, because the specifics matter, and they've been getting lost in the political noise. The deportation policies that lower courts had been blocking for months were blocked for a documented reason. They violated federal law and constitutional due process requirements. Mass deportations without proper hearings. Detentions without bond. Asylum claims denied without the process that statute and the Constitution require. The administration appealed every ruling, fought every injunction, escalated through every available procedural vehicle. And when those cases reached the Supreme Court, the court sided with the lower courts. The legal argument the administration had been making, that immigration enforcement is a purely executive function where the president has unlimited discretion, did not prevail at the highest level. What the Supreme Court ordered was not a reversal of immigration enforcement as a policy. It was a requirement that enforcement be conducted within the legal framework that Congress established and the Constitution requires. The distinction matters. This is not the court telling the president he cannot enforce immigration law. It is the court telling the president he cannot enforce immigration law in ways that violate the law. Trump's response, the open refusal to comply, the claim that the court lacks authority to tell him how to handle immigration enforcement, is the constitutional event, not a policy disagreement, not an aggressive legal interpretation that pushes the boundaries of executive authority, a flat refusal to comply with a direct Supreme Court order. That is a different category of action than anything the administration had done before in its confrontations with the judiciary. Here is why that difference matters constitutionally. The American system of government is built on the premise that each branch respects the determinations of the others within their respective constitutional authority. The judicial branch interprets the law, When the Supreme Court, the final arbiter of what the law means, issues a ruling, that ruling is the law, not a suggestion, not one opinion among many that the executive can weigh against its own legal analysis. The law. A president who refuses to comply with a Supreme Court order is not exercising executive discretion. He is claiming that his judgment supersedes the final legal authority the Constitution established to resolve exactly these kinds of disputes. That is the constitutional crisis. Not a rhetorical crisis, not a political crisis in the sense of bad polling, a genuine structural crisis about whether the executive branch will operate within the constitutional framework that 300 years of American constitutional history has established as non-negotiable. The founders built the impeachment mechanism specifically for this situation. They had just lived through governance by unchecked executive authority. They understood what happened when the person holding executive power decided the rules applied to everyone else, but not to them. Article 2, Section 4 of the Constitution provides the remedy. The President shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. The phrase, high crimes and misdemeanors, is not a reference to the criminal code. It is a term of art drawn from English parliamentary practice, used to describe offenses against the constitutional order, abuses of the powers of office, violations of the public trust, conduct that places the executive above the law in ways the constitutional framework cannot tolerate. Defying a direct Supreme Court order is not a close call under that standard. It is the conduct the standard was designed to address. H.Res. 353, introduced by Representative Shri Thanadar and now documented in the congressional record, lays out that case in formal legislative language. It details the pattern of conduct, the deportations without due process, the defiance of court orders, the claim that executive discretion overrides judicial authority, and argues that conduct warrants the constitutional remedy the founders provided. The resolution is now before the House Judiciary Committee. That is where impeachment proceedings begin. The process from here requires a committee vote, a full House vote on articles of impeachment, and then a Senate trial where conviction requires a 2/3 supermajority. Democrats controlling the House means the arithmetic for impeachment is there on the majority side. The Senate is where the numbers get harder. You need 67 votes, meaning a significant number of Republican senators would need to cross. That arithmetic has stopped 2 prior impeachments from producing removal. The first impeachment, Ukraine, abuse of power and obstruction of Congress, produced acquittal in the Senate. The second, January 6th, incitement of insurrection, produced 57 votes for conviction, 7 Republican senators crossing, still short of the 67 needed. But here is what is different about this moment, and I want you to think carefully about this because it changes the political calculation in ways that the previous impeachments did not. In the Ukraine impeachment, Republicans could argue, and did argue, that the facts were disputed, that the conduct, however troubling, did not rise to an impeachable level, that the process was politically motivated. In the January 6th impeachment, they could invoke First Amendment arguments, dispute the causal chain between Trump's speech and the violence, and characterize the proceeding as constitutionally improper because Trump had left office before it concluded. This is different. There is no factual dispute about what happened. The Supreme Court issued an order. The president said he would not comply. That sequence is documented, public, and uncontested. There is no factual complexity to hide behind, no disputed evidence to point to, no procedural argument that changes what the documentary record shows. Every Republican senator who votes against conviction will be voting to affirm the proposition that the President of the United States can openly defy a direct Supreme Court order without constitutional consequence. That is a vote that will follow every one of those senators for the rest of their political lives. The historical parallel that matters here is Andrew Jackson and Worcester versus Georgia. In 1832, the Supreme Court ruled in favor of the Cherokee Nation, establishing that the state of Georgia could not impose its laws on Cherokee territory. Jackson, who had built his political identity on Indian removal, allegedly responded that the court had made its decision and could enforce it themselves. He refused to comply. The Trail of Tears followed. The forced removal of the Cherokee people from their lands, a march that killed thousands, one of the darkest chapters in American history. Historians have consistently identified Jackson's defiance as the moment when executive disregard for judicial authority produced catastrophic human consequences. The constitutional lesson the Trail of Tears teaches is not abstract. When a president decides that court orders are optional, the people who bear the cost of that decision are the ones with the least power to protect themselves. The people bearing the cost of the current defiance are the individuals who were deported without the legal process they were owed. People with valid asylum claims, with pending legal proceedings, with legal protections that the administration chose to ignore. The Supreme Court order requiring real efforts to bring those people back is the court's formal acknowledgement that they were treated in ways that violated the law. The refusal to comply with that order is the continuation of that violation, now in direct defiance of the highest legal authority in the country. The enforcement problem is real, and it is worth being honest about. The Supreme Court has no army. It has no marshals who can physically compel compliance with its orders. The court's authority depends on the other branches respecting its rulings, the executive branch enforcing them, the legislative branch providing the legal and budgetary framework within which they operate. When the executive branch refuses to comply, the only constitutional remedy that does not require executive cooperation is impeachment. That is not a bug in the constitutional design. It is the feature the founders built specifically for this situation. Congress removing a president who refuses to comply with court orders does not require the executive's cooperation. It requires the legislative branch to do its job, to exercise the accountability power the Constitution gave it, precisely because the founders understood that executive power, left unchecked, tends toward exactly the kind of conduct this moment represents. H.Res. 353 is Congress beginning to exercise that power. Whether it succeeds depends on the arithmetic of the Senate supermajority and the political calculation of Republican senators who will have to decide whether loyalty to one president is worth the historical record of having voted to affirm that the president is above the Supreme Court. That calculation is happening in real time. The 2026 midterm elections are approaching. Every vote on this will be part of the public record that voters in every competitive district and every competitive Senate race will have access to. The political cost of being the senator who voted to let the president ignore the Supreme Court is not a cost that can be walked back once the vote is cast. The impeachment process that H.Res. 353 initiates is not guaranteed to produce removal. The constitutional mechanism is available. The documented basis for invoking it is clear. The political pathway through the Senate is difficult but not impossible if the conduct at issue is what it appears to be. A president openly defying the Supreme Court in a way that no prior president has done, on a factual record that admits no ambiguity. What the resolution does guarantee is a formal congressional response to conduct that the constitutional framework identifies as requiring one. The hearings, the evidence entered into the record, the votes cast by every member of Congress, all of that becomes part of the permanent documentary record of this period. Whether or not Trump is removed, that record will exist. The votes will be on the books. The conduct will be documented. And the constitutional question, whether a president can openly defy a direct Supreme Court order without consequence, will have been formally addressed by the institution the Constitution designates to address it. The founders built this system because they understood that no person, regardless of the office they hold, can be permitted to stand above the law. That principle is either real or it is not. The impeachment process is how Congress answers that question in real time, on the documented record, with every vote visible to every American who wants to see it. Let me be direct about what the pattern of this administration's relationship with the courts actually shows, because the SCOTUS defiance did not come out of nowhere. It is the culmination of a documented escalation that has been building since the first days of the second term. The administration's approach to judicial oversight has followed a consistent arc. When courts ruled in its favor, and there were significant rulings that went the administration's way, including on the shadow docket where emergency applications produced favorable outcomes, those rulings were celebrated as vindication of executive authority. When courts ruled against it, the response escalated through a sequence: initial compliance under duress, followed by appeal, followed by public attacks on the judges who ruled against them, followed in some cases by delays in implementing court orders that pushed the boundaries of what compliance actually meant. The pound sand moment, when a judicial ruling was met with public defiance rhetoric rather than legal appeal, established a pattern that the documented congressional record responded to. Judge Boasberg's contempt proceedings, the documented instances of administration officials publicly questioning whether courts had authority over specific categories of executive action, the statements from senior officials characterizing judicial oversight of immigration enforcement as constitutionally illegitimate, all of that built toward the current moment of open defiance. What changed with the SCOTUS order is the elevation of that defiance to the highest possible judicial level. District court orders can be appealed. Appellate court orders can be escalated to the Supreme Court. A Supreme Court order has no higher court to appeal to. When the administration's defiance reaches the Supreme Court level, the only remaining institutional response is the one the Constitution provides: congressional accountability through impeachment. That is not a dramatic escalation invented by Democrats looking for a political weapon. It is the constitutional logic that the founders built into the system precisely because they anticipated the situation where executive defiance of the judiciary would eventually reach the point where the judicial branch itself could not compel compliance. The Supreme Court cannot enforce its own orders. It depends on the executive branch to do so voluntarily and on the legislative branch to act when the executive refuses. The legislative branch is now being asked to act. H.Res. number 353 is that action being initiated. Whether it succeeds depends on whether enough members of Congress, in both chambers, from both parties, are willing to affirm that the constitutional principle at stake is more important than the short-term political calculation of party loyalty. That is a harder question than it sounds. Party loyalty is a powerful force in American politics, and the costs of breaking with your party's president are real. Primary challenges, donor pressure, loss of committee assignments, public attacks from the president's considerable social media platform. The senators who crossed on the January 6th impeachment conviction vote paid political costs for doing so. Some of them retired rather than face those costs in primaries. The calculation for the next group of potential crossers includes that precedent. But the calculation also includes something new: the factual simplicity of the current defiance. In every prior confrontation between this administration and the courts, there was enough factual complexity, disputed interpretations, contested evidence, plausible alternative readings of the legal questions to give political cover to members who wanted to defend the administration without explicitly endorsing the specific conduct at issue. The facts are disputed. The legal question is unsettled. This is a political prosecution. None of those formulations is available here. The Supreme Court issued an order. The administration refused to comply. The order is public. The refusal is public. The factual record is clean and unambiguous. A senator who votes against conviction in a trial premised on these facts is voting to affirm that presidential defiance of a direct Supreme Court order does not constitute the kind of conduct that the impeachment mechanism was designed to address. That vote, once cast, cannot be taken back. It will be on the permanent record of that senator's service, alongside the order that was defied and the documented refusal that generated the impeachment proceeding. Future voters, future historians, and future members of Congress who face similar situations will have that record to consult. The stakes of the current moment extend beyond this president and this Congress. The principle being tested: whether a president can openly defy a Supreme Court order without facing the constitutional consequence the founders provided for exactly that situation, is a principle whose resolution will shape the constitutional landscape for every administration that follows. If defiance is permitted without consequence, the lesson for future presidents is that the judicial branch's authority over executive action is conditional on the executive's voluntary compliance. That lesson, once established, does not stay confined to immigration enforcement. It extends to every domain where a future president decides that a court ruling conflicts with their policy preferences. The founders gave Congress the power to remove a president who puts himself above the law. That power exists because they understood that the alternative, a president who can ignore court orders without consequence, is not compatible with the constitutional order they were trying to build. H.Res. 353 is Congress being asked to use that power. The documented record of why it should is clearer than it has been at any prior point in this accountability story. The order was issued. The refusal was documented. The constitutional remedy exists. Whether the people entrusted with exercising that remedy have the institutional will to do so is the question this moment puts to every member of Congress whose vote will determine the answer. That answer will be on the record, and the record is what history reads when it decides what kind of country this was at this particular moment, whether the institutions held or whether they looked away when a president told the Supreme Court that its orders were optional. The founders feared exactly this. They built exactly the remedy for it. The only question left is whether the people holding that remedy are willing to use it. That question is now before Congress, on the record, in real time. Every American watching this moment is watching the answer take shape in the votes that will follow. What those votes say about us as a country, not just about this president, not just about this Congress, but about whether the constitutional framework built to prevent exactly this outcome still functions as designed, is the stakes of the H.Res. 353 proceeding at its most fundamental level. Subscribe to daily news. No spin, no corporate filter, just the documented record, delivered straight. Every day, stay with us. Stay with